We're pleased to have Keith Carrington back with us. Keith is a healthcare compliance professional serving a diverse group of clients, both covered entities and business associates. Keith has a law degree with a specialization in health law and a PhD in health administration and policy analysis. Now, his company is CRC Compliance, Inc. It's well-respected compliance and risk management consultancy. They focus on unique and highly complex needs of healthcare and those related industries. He serves clients nationwide. He's back and forth between here and Atlanta on a regular basis, and we're fortunate to have him speak not just for his first time, but I think his second or third time here at MOROF. Will you please give a warm welcome to Keith Carrington.
Good morning. Thanks, Hank. Appreciate that. I'll get you your 20 bucks afterwards. Okay. Good morning, everybody, and thanks for coming out this morning. I know compliance is everybody's favorite topic, so I appreciate that everybody's here this morning. You know, I do a lot of adjunct teaching, and at the start of any course, I usually like to get a feel for who's in the classroom and who I'm going to be working with. So, how many physicians do we have in the room today? Okay, we've got one physician. How many practice administrators and office managers do we have? All right. Anybody from the research sector? Okay, excellent. What about business associates? Okay, a couple business associates. For those of you who didn't raise your hand, speed dating is in the other room. So you might want to get down there now if you can. Otherwise, you're with me. This was scheduled to be about an 80-minute presentation, which means we're right on par with timeshares presentations that tell you that they only need 90 minutes of your time. Unlike a timeshare presentation that will actually take up 4 hours of your life that you'll never get back, I have a hard stop at 9. I've been told they're throwing me out by 9:05. So with that said, let's jump in. First and foremost, I'm not an attorney and I don't play one on TV. So don't take what I have to say today as legal advice, nor does it constitute a legal relationship, an attorney-client relationship between us. The information contained in this presentation is for informational purposes only. And as such, you should seek legal competent counsel on any particular issues that you may have. If you need a list of attorney referrals, if you don't have one, see me afterwards. I'll be happy to give you a list of board-certified health lawyers here in Florida, and I don't get compensated, so you don't have to worry about that. We're going to cover a broad range of topics this morning, and hopefully as we go through it, you'll see how the dots all connect, and if not, I'll try to connect them at the end for you. We're going to start talking about the implications of big data in healthcare, and then related to that, we're also going to talk about data security, cyber attack risks, which we see growing and on the rise. We're also going to talk about cloud and offshore access to medical records, as well as the implications for healthcare research and de-identification. We'll briefly touch on some international implications, again, more for the folks on the research, and I believe we've got one from the research field here today, so there may be some interest there. Then we're going to jump into emerging litigation theories for HIPAA violations that everybody ought to be aware of. We're going to focus on 2 key cases that were filed in Connecticut and Indiana last year, and what that means for everybody in the room. We're going to talk about changes within the Office of Civil Rights who enforces HIPAA. They had some key staff changes last year, and that means possible changes to how they go about their enforcement actions as well as their guidance. So we'll talk about that as well as their HIPAA audit program revamp now that they completed phase 1 of their new HIPAA audit program. We're then going to talk about the Federal Trade Commission and their push for enforcement into healthcare. And when we get to that section, that's usually where the audience gives a collective groan because now we're introducing a potential new regulator. Business associates in the room, don't worry, I haven't forgotten you. We've got a whole bunch to talk about today for you as well. And then lastly, we're going to close up and wrap this up with some healthcare compliance tips, because the question I usually get asked at the end of these presentations is, great, what do I do now? Thanks for scaring me. How do we do it? And it's not so scary, and there are some tips. So I'm going to share those with you before we conclude today. So let's jump in and talk about big data if we can for a second. Big data is sweeping healthcare. We see it growing even in small practices. If you take a look at the type of data that you may now be collecting on your patients, what are their gym memberships? What's their frequency? Are you able to interface and collect other discrete data from your patients through medical applications that may interface with your practice? Or do you have your patients provide questionnaires on lifestyle and you're collecting that data? And certainly there are benefits to big data. We hope that through the collection of this data and the analysis of data that medical practices are taking, it'll lead to better healthcare decisions. It'll improve protocols at the provider level. But with that also comes some risks. And the larger growth and creation of health-related data is oftentimes not subject to the HIPAA privacy and security rules. And one thing to keep in mind is that the privacy rule, when it was written, Congress wrote that on a case-by-case basis. As issues started popping up, we started seeing the privacy rule written and amended to address very specific issues. But there were gaps in that privacy rule. And what we're seeing is, with the influx of big data coming into healthcare now, those gaps are becoming more noticeable and they're becoming bigger. Because what we're finding is a lot of data around healthcare that ought to be protected isn't covered at all by HIPAA. I'm a diabetic. I have an app on my iPhone where I track my blood sugars, I track my meals, and I can interface that and send that electronically right to my doctor's office, which is great because I'm traveling a lot, so I'll just send that over to them. I'm not necessarily seeing them every couple of weeks. But that application isn't protected by HIPAA. In fact, the user agreement specifically says, hey, we're not required to comply with HIPAA's privacy rules. But at the same time, that is PHI that we are collecting. Certainly my blood glucose levels is health data specific to me and should be protected. And we're seeing that. We're also going to touch on this a little bit later about wearable data if you're a fan of the Fitbit and so forth. There's certainly great concern now at the federal level about how do we protect the data that's being collected and retained and who has access to that. Do the makers of these applications have access to any of that data as well? There's also, in touch with this, we are seeing that the federal government is starting to question this and starting to look at it. And what they're doing is, starting late last year, they kicked off some information gathering hearings, which is usually the start of the regulatory process before they start drafting their draft rules. So both at the FTC level, the Federal Trade Commission, as well as the Office of the National Coordinator for Health Information Technology, i.e. the guys you might know as the ones who provide the meaningful use incentive checks that you may still be collecting, have both started those hearings, and those are going to continue throughout 2015. They've already scheduled hearings out through August, and by March we should see the rest of the year's hearing schedules and dockets, both with the FTC and ONC, regarding this very issue. I think we're probably 18 months to 2 years away from seeing a draft rule come out. And I think we're going to see that come through Health and Human Services. It wouldn't surprise me if we saw the FTC try to issue one. We'll talk a little bit more about that when we get to the FTC portion of the presentation. But there are three big thrusts so far that Health and Human Services has said they anticipate coming out of these information gathering sessions and their initial rulemaking activities. And that is that there may be rules written and incorporated in HIPAA for what they call the non-HIPAA data. There may be new rules to supersede and revise HIPAA, or we may see a broad general privacy law, which is what the FTC is pushing for, that now starts encompassing a lot of that other data and how that applies. Obviously, everybody is familiar with and has heard about Sony, Anthem, Target, Chick-fil-A. I'm not going to ask you to raise your hand if you don't know about those, but if you don't know about them, please see me afterwards because you live under a bigger rock than my mother-in-law. So, but all of those organizations have had data breaches in the last 2 years, and they have been significant data breaches. And what that is showing us is that as we collect more data, as data becomes electronic medium, it's a high-value target for anybody who wants to get that data for any number of reasons. And the challenge, especially for those of us in the compliance side here in healthcare, is that when we talk with providers or we talk with a business associate, so either end of the spectrum, we can take the covered entity, we can take the business associate, the most often response I hear is, well, Sony's big, Anthem's big, Target, Chick-fil-A, they're all big. Nobody's going to care about me, the small guy, right? Well, if you remember my presentation 2 years ago when we were talking about the omnibus rule and its rollout, you might remember the story about the oncology practice, 60 providers in a suburb of Chicago that on a Tuesday morning walked into their practice and couldn't access their EHR. Somebody hacked in and had changed all of their passwords and then sent them a fax saying, hey, if you wire a nice sum of money to this bank account, we'll go ahead and release the passwords so you can get back in to your system. It took the practice almost a week to get all the passwords reset and able to fully function with their EHR again. This was an oncology group. Can you imagine the impact to their patients? And they are now on a corporate integrity agreement with Health and Human Services because of the very fact that they did not take necessary precautions within their practice. We've also learned that it was an employee who helped assist in that. And that's going to come to a common theme we're going to talk about a little later today is some of the greatest risk isn't from an outside hacker who doesn't know you, it's from your disgruntled employees, and the damage they can do is tremendous. The FDA has repeatedly, most recently 2 weeks ago, I saw another flash bulletin from them, warning about cybersecurity risks to medical devices. They are most concerned with pacemakers and what can be done if a culprit can hijack a pacemaker, or more importantly, can get into the system or a doctor's practice that has all the control information on those pacemakers. And from a security, compliance, and risk management standpoint, you're required to have ongoing and consistent reevaluations of your security risks. The fact of the matter is, as fast as the technology changes, so too do the criminals' aptitudes and skills. And what you want to be doing is constantly evaluating. Part of the issue that we've seen with Anthem and Sony and Target is that they set protocols in place and security measures in place to protect the data, particularly their customers' data, but they were antiquated. They're no longer practical. There are workarounds now to those, and those workarounds have been exploited. And that's what we typically see. So the takeaway at this point is you're collecting more data about your patients, whether it's PHI or just personal information about them that can lead to identity theft. You're collecting more information about your own practice online as well. And the risks are growing. They're not going to go away. We know we're going to see them grow over time. We're going to see more. 2015, we're going to probably see double the number of disclosures about large data breaches than we did the year before. That also means that there is a real onus on healthcare to get caught up with data security. Now, the security rule at HIPAA is rather comprehensive, and it's certainly not new. It's been around forever and a day. I'm surprised, as are a lot of other commentators in this field, at the staggering number of practices that are just truly not compliant with it. They have not fully implemented the security rules. They oftentimes say, we don't know how to, we don't think it applies to us, we think it's overly burdensome. But then what happens is when the risk is exploited, now they're all wishing they had been there. So as you'll see later in this presentation when we start talking about OCR, this is going to be a relatively quiet year for them. So I would suggest that this is probably the year that you really want to be taking a look at those. If for no other reason than the regulators at the federal level aren't going to be as active this year as they will be next year in auditing. So you might want to take that time where you might spend worrying about audits and actually take a look at your security and evaluate whether or not you are up to date and you are current, and check with your vendors as well, your EHR vendor, as well as if you're using IT, cloud-based vendors, you're going to want to make sure that they are working with you and implementing those security rule requirements. Healthcare research and de-identification is obviously one of those areas where there's great concern for security, but there's also a different concern going on in discussions at the federal level right now about healthcare research that for the research community they're happy to start seeing come around, and that is that whether or not the HIPAA rules create undue restrictions on research efforts. And again, this is tied back to big data. There are some of the privacy and the security rules that just are proving problematic for researchers, and HHS is finally getting their hands around that and starting to realize, you know what, there are some very overburdensome provisions here, and we may be stifling some of that research. With that, there is a growing view, both within industry and within the regulators, that these rules can be changed to permit broader activities while protecting patient privacy. There are upcoming at least 2 hearings in Congress scheduled for later this year to go ahead and address this very topic about whether or not On the research side, we can actually loosen some of those requirements. However, at the same time, again, that big data is creating some new concerns about de-identification and threats for re-identification of the data. Are you able to effectively, if you're now working with data sets of a couple million records, are you able to sufficiently de-identify them? Are you going to be able to properly re-identify them when you need to under the HIPAA provision? So there's a lot of moving parts to it. There's a lot that's going to be taken into account over the next couple of months and probably the next year. But I do think that if we see any changes in the short term to HIPAA, they're probably going to occur here on the healthcare research side as they start to relax some of those rules. There are also some international implications, and most everybody in the room may be sitting here going, well, what does that mean for me? You know, it may not be relevant. And it's true. For some of you, it may not, but for others of you, it might, particularly if you are engaged in clinical trials of an international nature. This year, we can expect some significant changes to an already confusing international data privacy environment. There are a number of privacy rules coming out of Europe. Some of them are not all codified and uniformed, which makes it even more confusing. We've got several out of Latin America that make it very challenging as well to understand. And even though, as I just indicated, most of our industry remains localized to a geographic area such as Orlando, Central Florida, the United States, there is increasing collaboration on that international level, particularly when we talk in the research arena. And that's where we see the concerns coming this year. The European Union Data Protective Directive, if that's not a mouthful, is scheduled to be revised this year. The proposed draft was published 2013. They gave a 2-year tail to that. So this is the year that they're going to be finalizing that at the European Union. There is an EU-US safe harbor built into that directive that exempts a lot of healthcare research and data transmission between the EU and the US, and that affects even same organizations. So if you have an international medical research company, you have a pharmaceutical company with US operations and European Union operations, they're oftentimes affected by this directive, and they rely on that safe harbor. Well, that safe harbor is under attack right now by the European Union. They want to do away with it. If not do away with it, they're at least proposing some material changes, which we expect will disrupt various research activities. There's also going to be some new compliance requirements on that front coming out. So from the research arena, we're going to watch very carefully this year because we can expect new compliance initiatives and new compliance requirements before the end of the year, and we're probably going to have a year or less to start implementing those. So shifting now, we've kind of gone through, at a high level, the big data and what's going on that side. Let's bring it now down back to a more local discussion at this point that may be a little more germane. And the first one is I want to talk about the litigation theories for HIPAA violations. As you probably all know, HIPAA itself does not provide for a private cause of action. So if my medical records are mishandled, mistreated, or improperly disclosed, I can't sue a provider based on HIPAA. There's no way for me to get into court under the HIPAA provision. How do I get into court? I get into court on my state's privacy laws. Because if you violated HIPAA, you've probably violated your state privacy laws, and that's how plaintiffs have been getting into court. Well, leave it to plaintiffs' attorneys to try to find new and innovative ways to help their cases. And they have, and successfully in both Connecticut and in Indiana in 2014. They were successfully arguing, and at the appellate level, in Connecticut at the Supreme Court and in Indiana at the appellate court level, that HIPAA now constitutes the reasonable standard of care that a medical practice should apply when protecting patient data. Now, medical practices are definitely aware of the standards of care. It applies in malpractice litigation all of the time. We take a look to see, did the physician's conduct fall below a standard of care or not align with a standard of care, and if so, does it rise to medical malpractice? Well, we're now seeing that same theory, at least, applied with HIPAA. And they're being used as an element, as I said, standard of care in a traditional tort case to help support that privacy law claim. Now, there are some significant hurdles that still exist to bringing such claims in state courts. However, I think those hurdles are going to be eroded over the next 2 years, especially if we see more cases successfully filed and using HIPAA as that standard. The two cases, which I'm going to walk you through both cases in a second, do remind us that compliance with HIPAA rules is paramount. Practices have to be paying attention to it. And most everybody goes, yeah, I'm HIPAA compliant. And then when you end up doing a thorough HIPAA risk assessment or doing an audit, as I frequently do, we find that there are significant gaps. So again, now's the time to make sure that you're paying attention to your HIPAA compliance activities within your practice. The purpose of the HIPAA rules is to protect the privacy rights of individuals. Keep that in mind. It is definitely stacked for the patient. And this now applies to business associates. So where doctors have had HIPAA around for a while and have had to adjust to it and work with it, the business associates are only coming into play since the compliance date is September 2013 for the omnibus rule. So this is going to apply, and we expect that if it's applying to medical practice standard of care, business associates, if you are involved in a breach based on your conduct or the conduct of your subcontractors or failure to adequately protect, you may find yourself as well in state court facing a privacy lawsuit, and you're going to hear that HIPAA coming up as a standard of care. And keep in mind, too, that the HIPAA rules do not provide us with a pass if our actions or inactions can be proven to be below the HIPAA standard of care and that they don't cause compensable injury to an individual. You're not going to get a pass if you, well, I'm mostly compliant. That's not going to be the case. It's going to be an all or nothing on that standard of care. And to bring that point to light, all we have to do is take a look at the first case, which was Byrne v. Avery Center for Obstetrics and Gynecology. This decision came down from the Connecticut Supreme Court in 2014, and it addressed two specific issues. The first one is whether the tort claim was preempted by HIPAA, as Avery had argued, or I'm sorry, as Avery had argued, stating that there is no cause of action, HIPAA should trump state law, and as such, we shouldn't be here. The second issue that the Supreme Court evaluated was whether the HIPAA rules provided an applicable standard of care that could be applied to the state's common law. In the first theory or the first issue addressed by the court, they said absolutely not. There is actually a provision in HIPAA that allows state law to preempt HIPAA. You can be more restrictive. So with that said, there is no preemption by HIPAA, and so as a result, the state claim could proceed forward. No surprise there. What was the surprise was that the Supreme Court did actually uphold the fact that the HIPAA rules, both privacy and security rules, do constitute an applicable standard of care. And if the plaintiff can show that the defendant did not adhere to that standard of care, i.e. did not comply with the privacy and security rules, then their claim could certainly move forward. Now, in this particular case, the plaintiff was a patient of the practice, and during the course of her treatment at the practice, she ended a relationship with a gentleman. The gentleman was potentially the father of her unborn child. She's obviously seeking treatment for prenatal care through the gynecologist's office or the obstetrics portion of the practice. The now ex-boyfriend wanted to know if he was the father, so he subpoenaed her medical records. Instead of one advising the patient that they had received a subpoena, and instead of attending the court hearing to argue that they should not release medical records to a third party, the practice simply turned over the medical records to the court. The court, through discovery, handed it right over to this gentleman, and he then started to proceed to harass the woman. And as a result, she alleged both negligence in the handling of her PHI as well as negligent infliction of emotional distress because she's now being harassed by this gentleman. And as the state Supreme Court ruled, as we had just talked on, they agreed that case may move forward, and damages were obviously awarded both on the negligence and on the negligent infliction of emotional distress. The Indiana case is a slightly different case, and we can distinguish it because in this case, the court was asked to uphold a verdict. And Walgreens versus Hinchey was a case where a pharmacist at one store misused Hinchey's personal data. In fact, the pharmacist sold the data to others along with other patients. Hinchey couldn't identify the other patients, so it never got to a class action. But Hinchey did win a $1.4 million verdict against Walgreens. Walgreens appealed the case and said, hey, you're applying a HIPAA standard of care. There is no such thing. It should just be governed under state law. And there, the issue really was, if we can throw HIPAA out as a standard of care, then the case couldn't be made at all, because the entire argument was predicated on the HIPAA privacy and security rules. And the Indiana court upheld the decision and said, no, absolutely not. HIPAA can provide a standard of care. So what does that mean for us here in this room? What it means is we may now start seeing more litigation. We anticipate we're going to see more litigation filed in 2015 and beyond, where now we're going to start seeing this come into play, whereas before, really the biggest concern for a medical provider, and initially back 2 years ago when we were talking about the omnibus rule, the greatest concern for the business associate was, what are the regulatory penalties for noncompliance with HIPAA? We really didn't talk about the litigation side of it, particularly in state court, because there was no private cause of action. Well, now we're seeing that the HIPAA rules may be applied as a standard of care, both to a covered entity as well as we expect to a business associate, since business associates are now held to the same standard of care when complying with HIPAA. So this particular case is subject to ongoing judicial review. The Indiana Supreme Court hasn't heard it. We don't know if they will. The writ of certiorari has been filed, or rather the application for certiorari has been filed with the court. We haven't heard if they're going to grant it. We expect later this year they'll determine if they're going to hear that case or not. If the Supreme Court looks to Illinois Supreme Court and they look at the appellate ruling, it's quite possible they're going to let the appellate court ruling sit and not take this up, and there's certainly a good likelihood that that would happen. So keeping in the theme of HIPAA for a second, let's flip over to what has always been the big concern for medical practices, and now more recently for the business associates in the room, and that's the HIPAA audits that OCR does. We know that over the last few years, the Office of Civil Rights had contracted with KPMG to help them with their audits in this new audit program that they wanted to roll out. Phase 1 completed last year. They're done with that, and this is the year in which they're going to be taking the lessons learned and they're going to be revamping the audit program. If anybody in this room has gone through that audit program, I'd certainly love to get your perceptions on it. I have 3 clients who went through initial audits. They were incredibly burdensome on them, and everybody who has gone through them had reported the same thing. They were just an absolute atrocious nightmare. Never seemed to end, couldn't get real clarity. You know, typically when we look at a federal audit or an examination of a company, under the Administrative Procedures Act, there is a prescribed method to how that audit is supposed to work. And it usually starts with notification 90 to 120 days out that you're going to be audited or examined, depending on what term they choose to use. And you're going to then get a production, request for production. And they can be quite long. I have seen them as long as 87 pages long, single-spaced, of provide us all of this documentation. And you'll provide it to us in advance. And they're going to then tell you in a supplement to that request for production how you submit that to them. And most everything is electronic submission. They're going to tell you what kind of file type that data needs to be in, how it needs to be uploaded to them. And then they're also going to give you what's called their in-hand production list. And that means, hi, when we come on site, you need to have this additional information ready to hand to our auditors on the first day. And then somewhere 30 to 45 days before the audit, they're going to call, and you're going to have a pre-audit call with your lead auditor. And they're going to walk through what their expectations are. They're going to let you know what kind of resources they're going to need when they get on site. Typically, that includes, we need a private conference room for the 5 to 8 of us who are coming. We're going to need internet connectivity. Will wireless be sufficient, or does it need to be wired? Sometimes they'll even tell you they need computers, because they're not going to travel with computers. It's not uncommon to see them tell you to please roll in a copy machine for me, because we're not going to use your copier out there. We need one in here, and it needs to be private so that nobody can see what we're photocopying. So it can be rather difficult, but at least there's a structure to it. What happened with the HIPAA audits in phase 1 was we outsourced to KPMG. KPMG is a company, not a government regulator. As such, they are not subject to the Administrative Procedures Act. So here we have a bunch of financial bean counters, and if anybody worked or has anybody who works for KPMG, I mean no insult to them, But quite frankly, we have a group of bean counters who are now trying to play as contract auditors for the federal government. You can imagine how well that went over. In the first round of audits, it was pretty much what I would call the Wild West of auditing. It looked more like a financial audit that you would come in on, or a bank audit, more than a regulatory audit, and that was the big issue. Practices did not get comprehensive lists up front of what they needed to produce to KPMG. They got a general request for some basic information, and then it looked like, oh, well, this audit's not going to be so bad if this is all they want. But then they showed up, and their version of an in-hand production request meant, I'm going to put it in your hand on day one, and I'm going to ask, please have it to me by the end of the week. And now we're talking about a 100-plus page production requirement. And if you can imagine, for a medical practice that's primary objective is to treat patients, how do you take your staff off on a Monday morning and tell them that they need to spend all day for the next 3 to 4 days pulling and copying every piece of documentation that the auditors want by the end of the week? Not to mention, they're already there starting Monday, so now they're going to start asking questions, and they want to walk around, and they want to do their observational auditing right now before they get that production. So it was a very burdensome process. HHS and OCR got a mouthful from a number of regulated covered entities about that process. They've acknowledged the problems with it. They are going to go back and revamp it. And the good news is that they're now, moving forward, going to be keeping that in-house, at least with their staff, and not outsourcing that. So that's a good thing. We do expect that the new program, once it's announced later this year, will be less intrusive. We expect that that program is going to ramp up next year. There is still, however, going to be significant work for the entities. I'm sorry, both medical practices and business associates. What you are going to experience is you're still going to get those production requests. There is going to be a lot of document preparation that you're going to have to do for them. Hopefully, though, it's going to be better aligned now with the Administrative Procedures Act, so you'll have more time, and you're not going to have this 3-4 days, go compile it while we're on site, which can really shut down a practice, preparing for that. Unfortunately, for the business associates in the room, you're now going to be fair game. They've already announced that. They're going to include a mix of business associates moving forward next year. It will not be 100%. However, as we're going to talk in a few minutes on the business associate side, there are some real challenges in terms of how do we audit a business associate, and they have not worked that out yet. So the good news for the business associates is, even though right now, here in end of February 2015, OCR is saying, oh yes, next year they're going to be included with covered entities, the reality is, I don't think it's going to be there, because they've got less than 10 months to figure this out and announce it. And I just don't see how they're going to have a working business associate model. What wouldn't surprise me is if we see a couple high-risk business associate classifications possibly included, and that would obviously be around your IT. If we've got such concerns around big data and cybersecurity, data security, it doesn't take much to realize that they may target in on IT providers and your cloud providers if you're hosting your EHR in the cloud, and want to look at those and come up with some audit protocols for those entities. Another thing that HIPAA, or that OCR has indicated about these audits, is that the good news is enforcement actions is not a primary purpose for the audit. Okay? That has been a big concern to date, is that when OCR comes walking in here, they're really looking for the gotcha. And in the past, they've justified that assumption, because that's what they've done. I mean, every time they've ever walked into a medical practice, it's how big can I make this fine? Because keep in mind, OCR is funded through the fines they collect. They don't get line item budgeting through appropriations from Congress. They get their money by what they collect. So it has long been the practice of one violation can turn into 5 violations, because I want to make sure that my paycheck that's supposed to be auto-deposited next Friday doesn't bounce. So that has long been problematic for OCR. It's been problematic around these audits, and what they have said is, no, we're not making that our primary focus. It's not our intent. The audit really is to see where the practice is, or where the business associate is, and we want to collaborate with them to help them improve their compliance when we identify gaps, and help them draft their remediation plans. But We'd also like to point out that if we find something that rises to the level of necessitating an enforcement action, of course, we're obligated to do so, and we will. So you can take that how you want. They are saying on one hand it's not a priority, but at the same hand, if they find something, they're going to fine you. So let's wait and see what happens. But I'd expect you should still be concerned about enforcement, and that's why you want to make sure before they get to your door that you're doing what you can. And now certainly is the time to go ahead, both for the covered entities as well as a business associate, to evaluate how you're going to respond to an audit when it comes out there. There is guidance out there on Health and Human Services. I can certainly send you that guidance if anybody wants to read it and not have to go hunting and pecking for it. I'll certainly be happy to send it to you about what you could expect in an audit and what the sample audit flow is. It may also be good. Some practices are now doing mock audits of themselves in different areas, especially the high-risk areas. Typically, they're medical billing because of Medicare compliance, payer compliance, but they're also taking a good long look at HIPAA right now and running some mock audits. So if you want information on how to do that, I can certainly give that to you as well. More than happy to. There's another piece of this puzzle which adds a little more ambiguity and will certainly make 2015 interesting as we watch what happens with both the HIPAA audit program, but with OCR itself. In 2014, especially second half of the year, we saw some substantial changes at the top levels of OCR. We appointed a new director and named a new director for OCR. We had a number of senior level directors underneath, or assistant directors, I should say, all of whom either retired or played musical chairs and started moving around. We also had two who left OCR and Health and Human Services. One went to the EPA and one went to Department of Transportation. So not really sure why they wanted out the way and moved to where they moved, but what that means is that we've got a lot of new faces in the top level ranks of OCR. And we don't know what that means. So far, we haven't seen any evidence of a new approach. It looks like OCR is going to continue with its approach as set out by the previous leadership. There's no indication right now that they're going to be making any sweeping changes, but we should be paying close attention. This year, a couple of key litmus tests for us to see if there's going to be changes. We'll be looking at their initial enforcement results in 2015. Are they taking a different stance? Are they cracking down harder on things? It'll be very interesting to read when they do take an enforcement action and the summary that they put with that. It'll also be very interesting to see their involvement in working with the Council for the Office of Inspector General on negotiating corporate integrity agreements and seeing what those terms look like and see if they're advocating for any different terms in those agreements. And I don't want anybody to overreact to any single enforcement action. If we see one where they seem overly intrusive or overly harsh in the action they take against a covered entity or a business associate this year, we shouldn't necessarily overreact to the one. We want to take a look at a sample of those and see if we're identifying a trend, because again, enforcement actions are on a case-by-case basis. You don't always get to see all of the juicy details behind it, but quite frankly, you could have one really bad actor who really needs a strong enforcement action. That's why you're seeing them come down overly heavy-handed in one situation. We want to see if that heavy-handedness continues through on a number of them, and then that may give us some indication that they're ratcheting things up. But right now, again, the point is there's no indication right now that there's going to be it, but we are going to want to watch that closely this year. And this is the point where now everybody can give that collective groan, if you would like to. There seems to be a turf war going on right now, and if not a turf war, at least an expansion of authority by the Federal Trade Commission. Now, for a long time, the Federal Trade Commission has been the default regulator for data security and data privacy issues, as well as consumer issues. And I'm seeing a couple faces go, FTC, what does the Federal Trade Commission have to do with healthcare? We've got HHS. What are they doing? HHS is kind of asking the same question right now, going, we're not sure what's going on over here. But the FTC believes that they actually have enforcement authority over healthcare entities. They filed within the last 18 months. It's taken 18 months to get that filed. but they've took action against LabMD, which is a fully covered, HIPAA-covered entity, subject to the full provisions of HIPAA. And they had a data breach and some data security complaints that were filed by patients. And those complaints were sent to the FTC, and the FTC decided that they were going to take on LabMD, and they filed enforcement actions in federal court against them. And there are two key issues right now that are being litigated because LabMD is fighting back in federal court right now on this and simply stating that the FTC has no basis to regulate them. And those issues are, one, can the FTC rely on its General Consumer Protection Authority to authorize an enforcement activity related to healthcare data? And two, can the FTC act where HHS has primary enforcement authority? And we know from the enabling statute for Health and Human Services that they are the primary regulator for healthcare. So if they're a primary regulator, to bring in another regulator would be a referral from Health and Human Services for something outside of its authority. So typically we see happen is when Health and Human Services, whether it's the Office of Inspector General or it's OCR or it's CMS, who's walking in and taking action on or examining a covered entity and now a business associate, if they find violations outside their scope, which usually they don't because their scope is pretty broad, and they usually keep it focused to healthcare operations under whatever it is that they're looking for. But in the event that they find something that falls outside of their scope, they can refer that over to another agency. There was no referral here. Health and Human Services was not aware of the issue. Consumers did not complain. No internal whistleblower complaint never made its way to Health and Human Services. Consumers simply went to the FTC and said, hey, my data was breached, my privacy was breached, and so I'm coming to you. And we suspect that that has probably happened because over the last 3 or 4 years, the FTC has done a great job of educating consumers that, hey, when you have problems, you come to us. And they've used those complaints now to take this action. They've also taken it against a timeshare company that doesn't believe they're subject to FTC rules because they have other regulators at the federal level themselves. So we have two parallel enforcement actions, both of which are being challenged. The only one I care about, the only one we should be caring about is the LabMD one. What is clear by the answer filed in federal court and all of the arguments presented by the FTC so far before a federal judge is that they are exploring their authority in situations that arise as a result of the gaps in the HIPAA rules. And we talked about this briefly back when we were talking about the big data, and the privacy rule in particular, we know has gaps. And we know that the federal privacy protection laws that the FTC enforces from a consumer's perspective addresses a lot of those gaps. And that's where the FTC sees itself coming in and said, hey, look, Health and Human Services, you've known about these gaps. You're not getting with the times. So you know what? We're going to go fill those gaps, and we're going to go regulate for it, and we'll provide the protection for the consumer. So healthcare is now squarely in the same consumer-centric regulatory environment that we find banks, financial institutions, and just about everybody else today. What is concerning for us is whether or not the FTC is going to be able to go ahead and now flex its muscles and take enforcement actions as yet another regulator in the industry. They also are looking at new technologies and what their role will be in regulating them. Again, if you remember earlier, we were talking about, and I said we were going to address it in more detail now, about wearable data and other forms of data, whether it's from a healthcare website, whether it's from my iPhone and my glucose monitoring, my diabetes monitoring, to pedometers, to the iHealth applications that Apple has launched. And the FTC is looking at this and saying, hey, we're the ones who need to regulate them. Because you know what? The makers of these technologies don't fit the current definition of what a business associate is. Apple, I don't think, wants to be a business associate in healthcare. In fact, I'm certain they don't. They've said as much. And Health and Human Services, in the current definitions for a business associate, even though rather broad, you have a really hard time bringing somebody like Apple in to the mix. Bringing Samsung into the mix is kind of hard. Some of these other manufacturers, those who make Fitbit and the counterparts to Fitbit, certainly they don't fit that mold. They don't look the same. And we're seeing that. I mean, we are at a point in healthcare where business, technology, and science are converging, and there are tremendous new opportunities. And we see those new opportunities every day, and we should be excited, and we should certainly embrace those opportunities. But as with any new opportunity, there also comes risk and there comes challenges. And we end up relying on both the legal system and the regulatory system to kind of help define as we go what that needs to look like. And so that is, unfortunately, part of the evolution for new business models or new advances within an industry. And we're certainly seeing that now. And I think we're going to see the FTC take a very extensive role. We know in their data gathering hearings that they're conducting this year, this is a very big push for them. They want to look at new healthcare technologies that fall outside the scope of what has traditionally been defined as being HIPAA covered, and they want to address those gaps simply because, one, Health and Human Services hasn't closed the gaps, and two, at least according to the FTC, they don't believe Health and Human Services has the right to go ahead and regulate what we would call a non-HIPAA covered party. So it'll be real interesting to see where that goes. We are going to look at it. I don't think you need to necessarily worry that the FTC is knocking on your door tomorrow. But for big players in the industry, this is a short-term concern. For all of us, it's a slightly more long-term concern. It'll be interesting to see how this plays out in the end. I promised I was going to get to the business associates and share some information with you. 2015 represents some significant challenges for you in this room. You know, 2 years ago, when business associates and the business associate agreement came under great scrutiny under the omnibus rule, there was probably a 70-30 split in terms of who wrote the business associate agreement. A lot of business associates, about 70% of them, were reporting that, hey, my clients don't have business associate agreements. So I'm writing the business associate agreement because we got to be compliant. So here, covered entity, here's the business associate agreement. And the doctor's looking at it going, oh, thank God. I don't have to take the time to write this. Or more importantly, great, I don't have to go pay an attorney $500 or more to go write one for me. Perfect. I'll sign it, you sign it, I get a copy, you get a copy. Great, we're done. We can check the box. We got our business associate agreement. Well, we live in a very litigious world, and if anybody wants to disagree with me on that, see me afterwards. But every time I say that, I never get any takers. So I must be right in that assumption. And guess what? Covered entities have realized, gee, you know what? I went back and I read that omnibus rule again, and you know what? I'm still on the hook for what you do. And worse yet, I'm on the hook for what your subcontractors do. I may not even know your subcontractor. I may never see your subcontractor. But I'm on the hook. So guess what? Yeah, you know that business associate agreement you gave me last year? I have a new one for this year. And in that, we are seeing the covered entities. And again, let me shift over to the covered entity side. You guys are doing what you need to be doing. Are imposing stricter contractual requirements, including broader indemnification and reimbursement frameworks. And basically what that says is they're tightening up the ratchet and going, no, 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 you are going to comply. You're going to prove that you can comply to us. And by the way, there's broader indemnification for us. You're going to indemnify us for a lot more things than you would before. And by the way, you're going to be reimbursing us for our costs. So if we have legal fees, we have court costs, we get stuck with fines, we want to come back after you. Now, on a state-by-state basis, since business associate agreements are not covered by federal law, but by the state law in which they're written, docs some of those indemnification clauses that you're putting into those agreements, and some of those reimbursement frameworks may not hold up in your states. And certainly in Florida, we have some challenges with a few, but it needs to be pretty severe before you're going to run afoul of Florida law on those. But you definitely want to be reviewing those associate agreements with your attorneys. Business associates, stop just signing on the line and thinking there's nothing to it. Read it yourself, and please get with an attorney. Have them review it. There's no harm, there's no foul. If you want to have a collaborative business partnership between you and a medical practice, then there's no problem having the basic framework of that relationship reviewed by attorneys on both sides to make sure that everything is working out. But business associates expect that you are going to have more pressure from your covered entities to go ahead and provide indemnification and reimbursement up to the amounts that can be asked for in the states that you're operating in, and understand there's going to be greater contractual requirements. One of the things that I will say that I am seeing with greater regularity in business associate agreements is a compliance attestation and audit program. Medical providers are accustomed to this. Medical providers frequently get harassed by their payers, whether it's Medicare, Medicaid, or private payers, Blue Cross, Aetna, United Healthcare, you name them. They all have compliance programs. And their contracted providers are very frequently handed a very thick document every year and says, hi, here is our downstream compliance program that you must comply with. And you're going to attest that you meet all of the obligations to this. And we'll periodically audit because we don't want to just trust your attestation. We're going to come out and verify. It's the old trust but verify approach. What we're seeing is that now is going down to the business associate level. And now medical practices are starting to, particularly larger ones, the smaller ones don't, and that's probably more of a resource issue at this point than anything. They don't have somebody to write and monitor that program for them unless they go to an outside third party. But certainly with larger practices, what they're doing is they're going to the business associate and saying, hi, here's the 2015 compliance program for our business associates. You need to review it. You need to attest that you're complying with it. And we may audit it, or we may ask for certain compliance samples over the year. We're going to test you and see if you're meeting certain requirements for it. And the attestation, obviously, is a big gotcha for you, because if you attest you're doing it and then something goes awry, and it goes awry because you weren't doing what you said you were doing, first off, I don't think you're going to be doing business with that medical provider anymore. But more likely, you may be subject to civil litigation for that false attestation. So again, you're getting squeezed there. We certainly understand why. You just need to accept that, hey, this is the changing realm we're working in, and this is what it's going to do business. But again, make sure that you're having it reviewed as well, so that that business associate agreement isn't written too overly broad. There are also very specific requirements as of September 2013's compliance date with the Omnibus Rule for business associates, and there are two that business associates seem to still be struggling with, almost 2 years later. And that is to implement compliance programs and plans. Medical practices have to have a compliance program, and they have to have very specific compliance plans around different areas. You as a business associate must do the same thing. Does it mean you have to go out and hire another staff member to be your compliance officer? No, there are third-party resources for that out there. However, you do have to have a compliance program of some sort, and you have to have plans. And what are those plans? The biggest plan you have to have is a testing and monitoring plan that says we within our organization will test on a predetermined schedule certain aspects as it relates to our business associate agreement. So you're going to look to the requirements of your business associate agreement. You're going to say, what do I have to do? And first off, you have to comply with the privacy and security rules, more so the security rules than the privacy rules, because privacy may not always apply to your relationship, but the security rules will. So you're going to be doing that testing. And this is where your IT vendors, and I know I see a couple IT companies in the room right now, you want to reach out to them, because from the IT and the security rule, those are the folks you want coming in and doing those tests, at least on a minimum basis annually, doing a network audit, doing an audit on your compliance with the security rule, and making sure you have all those IT protocols in place and that they're working as anticipated and as designed to do. Obviously, if they do a network intrusion test and they can get into your network very easily, you got to remediate that right away. And that's the second plan. When you do these testing plans, you need to also develop remediation plans. And those remediation plans need to be documented. And you need to say, here was the gap, here's how we're going to fix it, here's who's responsible for it within our practice, and here's the date that we anticipate that that's going to be done. Now, like any project, it may take you longer. You may get it done faster. So yeah, can you change that date? You certainly can. But you need to have that remediation plan in place, and you need to keep those remediation plans because they will be asked for both through litigation as well as through audits. Also, as I touched on earlier, the OCR enforcement approach to business associates is problematic. We have taken regulations at a textbook level and we've now said, we're going to apply it to business associates. Well, it was a little easier in healthcare to apply these rules because they were written with an understanding of healthcare and how healthcare operates. And granted, an oncologist is different than a cardiologist, who's different than a pediatrician. But there are some commonalities to the back-end processes and operations of those practices. Everybody bills insurance. You have PHI. We can address that. What isn't so clear is the business associates. We've got everybody from mailhouse and printers to telecom guys to IT folks to other consultants, to your lawyer, your CPA, who all may now be business associates. You can't audit every company the same way. I'm not going to audit an IT firm the same way I'm going to audit a law firm or an accountant or Hank. So OCR is going to have to come up with new protocols for how do we test this, because the textbook, single broad stroke, and all business associates are going to comply, that's not going to work. So unfortunately, in terms of how we enforce the rules, how we audit on those rules, is definitely going to be problematic for the business associates. I think it's going to provide consternation on both sides, from the regulator as well as the business associate. But I also think it's going to slow down the type of audits that we're going to see coming out of OCR for business associates. And again, if you're in the IT space, I'm sorry, you're probably going to be the first ones included in there, just given the nature of what you do, what you hold, and the impact you have on driving change within the covered entity. So with that said, I want to wrap up with these last two slides and go through, because a lot of people are probably asking now, great, what do I do? How do we do this? Business associates especially usually ask me at this point, compliance program, what does that need to look like? Well, first and foremost, and there are 7 tips here, or 7 elements for an effective compliance program, and these come from Health and Human Services. They have said when they evaluate a compliance program from medical provider and now from business associate, these are 7 things that have to be there. 1, you must implement written policies, procedures, and standards of conduct. And the first set I would say that you focus on are those 55 that are required of HIPAA. Get those in place first, and then you can start building out the others. But you must implement those. It's not enough to just put them in writing, put them on a binder, or save them on a network drive and say, yep, we're done. You actually have to implement them. You got to make sure that they're being followed. They're going to want to see those in place. Designating a compliance officer and a compliance committee. Now again, this is definitely apparent on the covered entity side. There are Medicare requirements for this as well. There are other payer requirements for a compliance officer. We don't necessarily see that on the business associate side. This is one of those rules or elements that could be problematic, especially for a very small business associate. But you should have somebody who's handling your compliance either internally or externally if necessary. You need to conduct effective training and education. And again, keep records of them. Are you training your staff on what HIPAA is and on what your involvement with PHI is, especially on the business associate side? Developing effective lines of communication. How can complaints boil up? Doctor, how can your staff report if they think there's fraud, waste, and abuse? How can they report if they think there is a HIPAA violation? Any other kind of violation. Is there a way for anonymous reporting? Do you have anti-retaliation policies in place that go to that? Conducting internal monitoring and auditing. We just talked about the testing a moment ago, so I won't belabor that point. Enforcing standards through well-publicized disciplinary guidelines. What are your disciplinary guidelines? They need to be in writing and they need to be publicized. Your staff needs to be reminded, you do this, this is what can happen. And then responding promptly to detected offenses and undertaking corrective action. And that goes back to those remediation plans. Don't wait for a breach. If you find you've got a gap now, address it now as opposed to later. If it's a really expensive and you don't have the budget to handle that right now, find alternative ways at a lower cost that you can do the stopgap now and work for it just as long as it's reasonable. And that's what they're going to be looking for. And keep in mind, if you have a compliance program in place and you do end up facing an enforcement action, you will get better treatment from the regulators, and they have said this. Trying to comply goes a long way in terms of determining how heavy-handed they come down in that enforcement action. If you just thumb your nose, they have zero sympathy, and they are going to come at you with everything that they can. But if they see a company that is doing its best, they're trying to, but you know what, we just missed a couple things. 1, there may be no enforcement action on the audit, as they've said. Or 2, if it does come from complaints and they're looking at enforcement action, that fine may be significantly reduced. Other actions, they may not look to exclude you covered entities from federally funded healthcare plans. And then lastly, what are some tips? How do we create a culture of compliance within our organization? First, make your compliance plans a priority now. Don't wait on that. And know your fraud and abuse areas. Know where your highest risk is. Manage your financial relationships. And this is probably the biggest one, this next one. Just because your competitor is doing something, don't. You know, oftentimes, and we see this at the local level with smaller organizations. Oh, my competitor is doing this, so I have to go and I have to do that because I've got to compete with them. You know, they're taking my patients if they're doing this. Yeah, maybe they're taking your patients today. Let them get closed down 2 years from now, and all those patients are going to be coming back to you anyway. So, you know, don't do what they're doing just because they're doing. And Health and Human Services has published a toll-free number where you can call and you can ask for guidance. And you can report suspicious practices safely, and that's the 1-800-HHS-TIPS. Use the number. It's surprising how underutilized that number is, both from a reporting standpoint but also from seeking guidance. And when in doubt, ask for help. Reach out to your attorneys, reach out to your peers. If they've got a compliance program, find out what they're doing. Reach out to consultants, but try to find that help. And don't forget, Health and Human Services itself has a deep library of resources and guidance that's there to help you, both covered entities and business associates. And so with that said, I see I'm about out of time. I'll turn it over if there are questions.
Thank you, Keith. Let's give it up for Keith Carrington. Some great information today.
Thanks, Hank. Thank you.
And while you may not need help, you might have some questions. Please give me an opportunity to come to you so you can ask your question with the microphone there. Do we have any questions for Keith at this time? Keith, I just need to ask a question about some of the things that just stand right out to these folks that come in and do the audits.
Okay.
They're looking around in office. Are they looking for secure doors to the IT department? And as long as it's secure with some kind of code, they're okay? They're looking for information that's just left out in the telecom room, such as an IP address that could make them have a hacker get in and keep them from getting in and out of the internet? What are some of the things that just are like right out there?
Sure, the big red flags, in other words, for them. When an auditor is on site, keep in mind everything is fair game. Everything they hear, everything they see is fair game to them. To Hank's point, yes to all of the above and then a lot more. If you have IT servers, you've got an IT server room, they want to know that that's secure. They have not gone so far as to state the type of guidance. Does it need to be biometric? Can it simply be a key? That's fine. Expect they're going to follow up and they're going to want to know who has access to this room. We want to see the list. So you better have a list of who has access to it, or create the list and tell them who has access and justify why they have access. If your front desk receptionist has access to the IT room and she's 19 years old and she's just your receptionist, they're probably going to wonder, why does she need to be in the server room? And then they're going to tell you, you need to revoke that access. She doesn't need to be in there. So obviously your sensitive areas you're going to want to watch for. And yes, they are going to absolutely look for PHI, anywhere they can find it. If you have an open lab setting, and I've seen a traditional footprint where you'll have exam rooms and treatment rooms running down L-shaped corridors, and then in the center you've got this open pod, and it's your internal lab, because you do your own blood work and you can do limited lab work. They're going to be looking to see, are lab results just being left out on the counter? Because you know what? Patients have to pass that open pod as they're going to a room. I don't want to be able to look down and see and find out that my wife is here, find out that my neighbor is here, or maybe my boss is here, and I just found out he has HIV. That was a lawsuit that's now making its way through, and HIPAA will probably apply as well. So those are concerns for them. I have seen the auditors actually go through your garbage cans. In the middle of the day, they're going to walk up and they're going to say, "Can I see your trash can?" And they will pull every document out of that trash can and they're going to look at it. And if it's PHI, they're going to go, why is this in a trash can and not a shred bin? Not supposed to be here. And their attitude is, if I could access it, a janitor could access it. So yeah, they will look for that stuff. And they can sometimes be very sneaky about it, but keep in mind their ears and their eyes are always open.
Great. Thanks, Keith. Dan.
Yes, Keith, just a simple question because I call on regularly medical practices.
Sure.
And I'm amazed at the range of different sign-in sheets that they have available to sign in. You know, some just cross it out with a black pen. You know, there's all sorts of crazy ways. I can visibly see most of them. Now, I'm HIPAA compliant and trained, but patients certainly aren't. So what do you see, or is that a stepping stone that they would look for as well?
The HIPAA sign-in sheet can be an issue for them. Obviously, they like the peel off. They like something that you can completely obscure the name with. Obviously, the black Sharpie works to an extent, but if they can pick it up and read the name, it can be an issue. I will tell you, though, that sign-in sheets are not their first stopping point in an audit. Now, if you remember what I had said earlier, if over the course of the week, or 2 weeks, or 3 weeks, or 4 weeks, or however long they choose to be on site with you, hopefully it's a week, if they find a pattern of noncompliance and this attitude of, we don't think this really applies to us. Remember I told you they get a little nastier? Guess where they're going to go? Now that sign-in sheet has just become paramount to one of the auditors, and it is the biggest concern for that auditor. And what do you mean you're not doing anything, and I can see all the patients who checked in today? Or worse yet, I see the patients you checked in yesterday because you're so cheap, you're not even changing the sheet at the end of the day. If there's room, you're just leaving it on there until you fill up the page. And you're not doing anything, then yeah, now it has become an issue. If you're absolutely compliant, you're probably going to get them to go on a sign-on and say, hey, look, you really ought to think about your sign-in sheet and make some changes to that, and here's some recommendations. And they'll leave it at that. And I've seen that happen. And I've been there when they will pull them aside and say, hey, you just want to fix this. In which case, I usually stand there and go, told you so. But I've also seen where they come in and the medical practice just really is hostile. They're antagonistic. And they're usually hostile and antagonistic because they're scared, because they know they haven't done anything, and that's blatantly apparent to the auditor, in which case then again that sign-in sheet just becomes one more thing that they can fine you for.
Martin.
Actually, it's a two-part question.
Sure.
My name is Martin Forster, and I've got two questions, basically. To what extent are they looking at mobile devices? For example, cell phones, iPads, that sort of thing, because increasingly, either legitimately or illegitimately, a lot of information can be stored by an employee on that. And the second question is, what about offshore service providers? Increasingly, we're seeing a lot of virtual assistants in the Philippines, in India, and various other places, and of course, a lot of data backup. How are they handling that?
Hopefully, I will remember both of your questions. If I don't, just remind me. My brain has limited capacity these days. Your first question was mobile devices and what are they looking at. That is an absolute concern for them in the practice. Tablets, let's start there. They're used. Doctors use them. The medical staff uses them. I mean, I have watched, and as a patient myself, I have watched my own patient flow through the practice start on a tablet, end on a tablet. And sometimes it's the same tablet. The tablet gets handed to me. Here, the doctor will be in, and they'll just set the tablet down next to me because my flow that day is on that tablet. Others, it's interchangeable. The nurse walks in with her tablet. The doctor comes in with her tablet. Discharge planner comes in. Oh, okay, your surgery scheduler comes in. They've got their own tablet that they're working with. To the extent that those tablets are secure and then they're only processing the EHR, they don't have other applications on them, they're fine, but they are going to look to see what's on that tablet. They're going to want to look to see if you can record anything on it. In terms of mobile devices like cell phones or personal tablets by staff, they really frown on those unless there's a necessity. We understand doctors use them. 3 of my 4 doctors that I regularly see usually pull out their iPhone or whatever other phone they have, and they're looking it up, whether it's a drug interactions chart or it's other information that they want to get to. They understand that the physicians have them, and they understand there's a need for that. So they kind of go back to the same question that was posed to the 19-year-old receptionist with access to the server room. Why does this person need a phone? Because your reception staff certainly doesn't need them. There's a phone on the desk. They do not need their mobile phones. They should be away. They should be stored locked. Other industries, financial services, we see cell phone lockers. I think within 5 years, we're going to see at least guidance, if not a mandate, that medical practices should probably have cell phone lockers for their staff to literally lock them up. You can get them on break, you can get them on lunch, or keep them in your locked car. The biggest concern there is with taking pictures or recording things and then posting them. We have seen cases where medical staff thinks it's great. Oh, I'm going to go take a picture of, you know, it's Susie's birthday. Everybody get together at the front desk. We're going to take a picture with Susie because it's her birthday, and then we're going to post it on Facebook. And you got 3 patients standing in the background that can be seen and identified. So it is a concern. What I would say for the medical practice is take a look at who's using your devices. You should have a mobile device policy, and it should be restrictive. Right now, I would say keep it in a purse for ladies, gentlemen. Keep it in a locked drawer at your desk if you're on staff and not a doctor or a nurse who needs it. Otherwise, keep it in the car. But yeah, they are doing that, and we're going to see more of that coming down. So it's a growing concern for them right now. There's just no real clear guidance on what needs to happen with that, and I think we'll see that set over the next year, 18 months. With regards to your second question, and correct me if I'm wrong, but that was about offshore providers and support staff. That's a growing concern, and that goes back to both the international and the offshore components that we talked about a little bit earlier. International data protection laws, such as the EU directive, govern a lot of those relationships. Once they're offshore, they're hard for us to go ahead and regulate and enforce. But what we can do is, and what we are going to see even this year, we're going to see greater enforcement activity on this side of the pond, whatever pond you want to try to cross with your offshore provider. But we are going to see that they're going to start taking greater enforcement actions on your end and expecting that you, as the covered entity, are looking at those offshore support providers and what they're doing, either through your business associate agreement or through your service agreements if you're using a cloud provider. And with that said, we'll also say it's very nebulous, and there are big gaps. So I think right now the regulators are trying to play catch up with that, and they're still trying to get their hands around it. Part of the concern is what happens with the EU directive and that U.S. safe harbor. If that goes away or is as drastically revised as is proposed, that's going to increase compliance on this side for us, and I think that will address some of those concerns, certainly from an EU standpoint. But we're not so comfortable with that because it's going to disrupt in the short term some research operations that are then going to have to be recalibrated to meet the new standards. So I would say more to come on that. It's still a little nebulous, but I think we'll have a much better picture on that by the end of this year. Great. Did that answer your questions? Okay.
Well, that was excellent. Keith, thank you so much.